welcome to our City of Laredo Board of Adjustment meeting. Today is November 17th, 12 p.m. And I'd like to call the meeting to order. We'd like to begin with the roll call.
Thank you. Chairman Francisco Pancho Averill, I believe he's online. Mr. Richard Norton.
Here.
Mr. Jose Gonzalez.
Jose is here.
Here. Javier Martinez. Javier Martinez. Louis Laveau.
Here.
Mr. Richard Perales.
Here.
Mr. Javier Compián.
Here.
Mr. Guillermo Cavazos. Here.
Here.
And Mr. Osvaldo Lara.
And the chairman?
And the chairman, Mr. Averill, he did check in.
Here.
So there is a quorum.
There we go.
Okay, thank you, everybody. Next, I'd like to consider the approval of the minutes from our last meeting, which was, wow, surprisingly, almost an entire year ago, from December 11th. Mr. Snyderman sent these out via email, so I'll give a second for everybody to just have a chance to review them.
I'd like to move, Chairman, that we approve the minutes, the regular meetings of December 11th, 2019.
We have a motion to approve the minutes.
Can you, when you're providing a motion, can you please say your name for the record?
This is Richard Perales.
Thank you.
Mr. Perales has made a motion to approve the minutes. Is there a second?
This is Javier Compián. I second that motion.
All in favor?
Aye.
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 Aye. Aye.
Okay, the next item on the agenda, number 4, is the election of officers. So it looks like we need to nominate and elect a chairperson and vice chairperson.
This is Rick Norton. I nominate Pancho Averill.
I second the motion.
All those in favor?
Aye.
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 What about for vice chairperson?
I nominate Mano Cavazos.
I'm humbled that you would nominate me, but I believe that this is my last month serving on the board, since my council member is not going to be reelected.
Well, Mr. Cavazos, you may be appointed again by whoever follows you. So if the case that we lose somebody, we'll have another special election to.
I just thought I'd let everybody know. Okay. Is there a second?
I second the motion.
All those in favor?
Aye.
Aye.
Okay, the next item is the training for Board of Adjustment members, and this is where I think I'll turn the floor over to you, Kirby.
Thank you very much. Board members, building and planning departments, staff, it's a pleasure to have you here today. I'm going to ask if everybody could mute their mic. And the reason for that is we want to maintain the best audio quality we can. We're recording this, and so it'll be on YouTube for future reference if anybody wants to refer back to this, whether that's staff or board members or the public. If you forget to mute yourself, I will mute yourself if there's feedback issues. Please don't be offended by that. It's just really to keep the audio quality as good as possible. Now, if you want to unmute yourself and speak at any time, feel free to jump in at any moment and comment. This is okay, so with that said, let's get on with the training. We're looking at like 30 minutes for this training. We do have some new individuals who've never, new staff members who may not have had this training. And I believe there might be a board member too who missed the training last time. So this is going to be new for some folks, and for others, it will be old. But what we're going to go over today, the rules governing the Board of Adjustment, how Board of Adjustment meetings should be conducted, the ethical guidelines that are required by the city's charter, and we'll just open it up for general discussion should you have any questions about how things work. So, and
I already put it up here so when I can hear him talk.
Hello, I think we've got somebody unmuted. Javier, could
It's
you mute?
connecting again.
Javier, could you unmute yourself, please? All right, sorry about that.
I think he's having network issues.
Thank you, Jerry. Okay. So as far as the rules governing the board, let's talk a little bit about the general power of cities, where cities get their power. And they get it in three general areas. One category is administrative. You know, the city is, in effect, like a big business, and it has powers to hire and fire just like a business would, and make internal decisions that are decisions made by management and by directors. But then the city has specific police powers that have been given to it by the state. The federal Constitution has a clause where it reserves all powers not explicitly spelled out. It says those are powers that belong to the state. And then the states get to determine what kind of powers go to the cities. And so really, when we talk about local rules here in Laredo, all of our power, all of it at a local level is derived from the state. The state can give us more, sometimes it can take it back. And so we're going to be talking about the Texas Local Government Code because that's a big part of where our rules for the Board of Adjustment come from. That's something the state has ruled on and sometimes comes back to and redefines. And then, of course, we have planning and development powers. Again, those are from the state, but those are powers on how things are developed and laid out, where things can go where, what uses, and what types of buildings, etc. Now, just like I said, we get our authority from the U.S. Constitution. The Constitution says whatever power is not explicitly spelled out here belong to the state, and then the state divvies up what belongs to the state and what belongs to the cities. But essentially, it's all state powers. And Texas is one of those that gives a little more on average compared to other states to local municipalities to be self-determined depending on how big it is. And so we are a self-governing city. And then, of course, we have a city charter, which we're required to have by the state law. That spells out the rules that we have, and then we have ordinances on top of that. So why do we regulate development? There are some reasons why, and then we can talk about how. We are required by the state of Texas to have a comprehensive plan. We are required that our decisions that we make on land use should be guided by an overall plan that says where and how development should occur. We also regulate development because we want to reduce land conflicts, land use conflicts. You know, your property owner next door, you may have had a dispute sometime in the past about where leaves are falling or who's responsible for what. And, you know, if we left that all up to people to determine, there would be a lot of discrepancy. If you decided one day you woke up and said, hey, I want to start a drive-through business on my property, that's going to create some issues with your neighbors. And so a big reason that we regulate land development is to make sure that we put like uses by like uses so that we can minimize issues. And overall, what we want to do is create a good quality of life for the people that have to live and work together in a community. Now, we do that through our ordinances, our zoning, subdivision, and unified development codes, and through development agreements. Now, ordinances are rules that are put in place by the city council. So our zoning and subdivision rules, those are all really ordinances. Developer agreements, something a little different. Those are agreements that the city enters into with specific developers where we might decide, hey, these are the rules, but can we add some extra rules on top of it and you'll get some benefit? Often we do that if we're letting them use something that we have. Like we might have city land and we say, hey, we'll enter an agreement with you. We'll let you use this land, but you got to give us a little something extra as well. And so the state allows us to enter into development agreements like that. So these are just a little bit of kind of overall, give you an overall picture of the city and the rules that we have. Specifically for the city, if you ever need to reference this, you can come back to this training to know where we get these rules in the state, the local government code, the LGC, chapter 211, 212, and 213. Those have all the rules we just discussed about local governments, the zoning authority, the subdivision authority, the authority we have to divide up properties into lots, and then the rules that are there that we have to have a plan. So if you Google Texas Local Government Code, Chapter 211 or 212 or 213, you'll get those specific rules, and they're not really that long. If you ever wanted to read through, you could. Also, we have our city charter, our land development code, and our subdivision ordinance. The city charter, that's on the city's main webpage. If you Google Laredo City Charter, it will pop right up. The land development code and the subdivision ordinance are on our website. Let me bring that up. The cityoflaredo.com/planning. That's our planning department website. And there's some buttons in the middle. We've got our land development code. Those are our city ordinances specific to land development. And then we've got our subdivision ordinance. Those are our ordinances that deal with lots and developing property and access, all those rules like that. And then there's, of course, some other information we might come back to in just a little bit. And I highlighted these in red because right now we are involved in Project Recode. The comprehensive plan for the city that was adopted in 2017 stated that we need to update our code to reflect the vision of the city. So we're actually involved in that right now, and very soon we're going to be coming back. We'll probably call another meeting to get your opinion on some of the changes we're making to the land development code. We're going to do that with the Planning Commission, the City Council as well. And then we're going to bring it out we're going to email it out to the whole public so everybody can take a look at what we're proposing.
Kirby,
So, yes.
let me ask a question. What type of changes would they be?
Mr. Averill, your audio is coming really good now. Thank you for fixing that. Sorry about the problem before. They're going to be widespread. If you look at our land development code and our subdivision ordinance right now, it's over 400 pages of code. So we're changing to make things simpler. We're combining things. We're updating things because the rules have changed for the state on many of these rules that we put in place. They're no longer valid. We're also making some changes based on what the comprehensive plan has said and feedback we've gotten. For example, one of them is that generally we need to allow for more density where we can. And so the setbacks are going to be changing in all of our residential zones to allow people to have more buildable area on their lots. You know, that came out of the comprehensive plan. So there's going to be changes like that, you know, in those three categories, combining, making things simpler, bringing things into compliance with new rules, and then following our comp plan and changing our rules to what the public has said they wanted.
Remember, one thing that we've always discussed is the fact that if we make a decision and tell somebody, you know, deny the approval of a variance, many times these people are going back and doing it anyway.
Yes.
And what I'm hoping that the committee would be looking for is something that had a little bit more teeth in it.
Yes, those are issues that we addressed when we looked through our enforcement. We went through with all city staff, took quite a lot of time, many hours of time, but we went through staff and said, where are the problems in the code? That was one. Mr. Orozco, do you remember that conversation, our zoning enforcement supervisor, where we talked about, he gave us his feedback, like exactly what you said. In some areas, there needs to be some more teeth. So those are issues we discussed. Okay, so moving on, let's talk about now specifically, well, we're going to start talking about the Board of Adjustment, but one more general thing I want to talk about, and that is that the city makes a lot of different types of decisions. And I want you to think about it in three types of categories. The city makes legislative decisions, ministerial decisions or administrative, you could call it, decisions, and then quasi-judicial decisions. So legislative decisions are, typically, well, not typically, they're exclusively done by the city council. If somebody is requesting a zone change, essentially what they're saying is, can we use our property? Can we put this type of thing here? And the state has decided that's a legislative decision. You can decide you like it there or you don't like it there. And if the majority of the elected officials want to use the property, want to see that property be used that way, they can use their discretion there to say, yes, that's what we think. And legislative acts are also all the rules that we put in place, all the ordinances. When we change the ordinance or we change the city charter, those are all legislative decisions. They have to be made in an open meeting with public input where the public can have a say as well. Now, once the rules are made and the rules need to be followed, a long time ago, 200 years ago, there was just city councils in cities. And what they found is not only did they have to make all the legislative decisions, but then anybody came to do a rule, they had to handle those too, and it was just too much. So it became common practice as cities evolved in the United States to create boards to carry out the rules that the city council put in place. So a good example is city council says this is what belongs here, and then someone comes in to actually build on that lot. They don't have to come back to the city council again. Now they go to the planning commission who says, okay, these are what the rules are, and you either meet the rules and get to build it, or you don't meet the rules and can't build it. It's no longer a decision of, oh, I don't like this developer, I don't want him to build there. No, it's an administrative or a ministerial decision. And then finally, there's quasi-judicial decisions, like the Board of Adjustment is a quasi-judicial body where somebody is making a case that, well, that we tried to follow the rules, but the rules shouldn't apply because there was something that went wrong or we needed an exception. And then you sit as judges or quasi-judges to say, not only about the rules being followed, because sometimes the rules can't be specific enough to address certain problems. So then you have to use your best judgment to say, is an exception to the rules warranted here? So those three types of decisions the city make, but I want you to think about it as well as changing the rules versus allowing exceptions. As the Board of Adjustment, you shouldn't be changing the rules. Your decision should be, hey, do the rules here, are they written in such a way that it didn't anticipate this case? And in this case, we need to allow an exception or we're hurting this individual. We're going to get a little bit more into that, what that means. So now talking about the Board of Adjustment, it's officially, the title is the Zoning Board of Adjustment. It is a, quote, sovereign board, unquote. What that means is that the decisions you make as a board can't be overturned by the city council or anybody else at the city level. If somebody doesn't like the decision you make, they have to file a case with the district court. So in other words, your decisions are pretty important, pretty final. Now you have two types of appeals that are going to come your way. You have administrative appeals and substantive appeals. Anybody remember the distinction between those two types of appeals? So when someone makes an application to the Board of Adjustment, they're coming to you with either one of these two appeals. Any of the board members want to take a wager of what the difference between those two is?
I'm guessing that administrative might have something to do with the process of getting an approval from the city.
Very good.
The red tape.
Versus what is a substantive appeal?
That is actually where somebody is in violation of zoning or the building development code.
Pretty good, pretty good. You hit the nail on the head with the administrative, and that is with an administrative appeal, somebody is saying the city did something wrong. We didn't follow the rules correctly. I'll give you a good example. Let's say somebody came in with some plans and came to our plans examiner, one of our planning examiner, our supervisor, Marco Gutierrez. Mr. Gutierrez, you never make a mistake on any plans examinations, do you? Marco?
No, sir.
Right, there you go. He never makes mistakes. Now, in reality though, Marco, occasionally mistakes do happen, right?
Yeah.
And it's very rare. I mean, we do a very good job. There's very thorough review, but we're human. And so sometimes mistakes happen. So let's say plans came in, Mr. Gutierrez, and we approved plan that said somebody could build even though it was in the setback. So they actually couldn't, but because we accidentally approved it, that would be a mistake on our part. Have you ever seen that happen, Mr. Gutierrez?
Sometimes happen.
Yeah, sometimes it does happen. I mean, we're, like I said, we do a very good job. We're very thorough. There's several people working on this, but occasionally it does happen in the planning department and also in the building department. If we accidentally allowed that, they're actually allowed to build it. You know, we can't come back a month later and say, hey, we approved this plan, you started construction, but actually, no, we were wrong. So in the case where we make a mistake and we acknowledge it, you know, we know that people can continue to build something even though we said, even though it's against the rules, but we originally said they could. But what happens, you'll find, Mr. Cavazos, is that somebody makes the claim that we made a mistake. And where we don't agree, that's where it ends up on your table. Because somebody's saying, somebody might claim that, oh, no, the city said I could do this, and now I got to stop work order. And we'll come as city staff and say, no, we never said that. You know, and it's the burden is on them to say, where's your evidence that the city said you could build this? Because I'm sure you've heard that a lot, right, Mr. Cavazos? You've heard them come and say that the city said they could do it, right?
I believe so, yes.
Yeah. So that's an administrative appeal. When somebody's coming and they're coming to the Board of Adjustment because they're saying the city screwed up, they made a mistake, and so I should get to continue to do what I'm doing here. And
Question though,
yeah,
going back to the administrative, we've had cases that have come to us where the plans were actually signed off on, and yet it came to us. Well, if they were signed off on and it was already noted that there was an error, why does it then have to come to us if it's an administrative process?
that's a good question. I haven't been here during a situation like that, but
We've had it.
if the plans have been approved, they are vested by the state law. So it doesn't need to come to Board of Adjustment. Maybe staff member thought, oh, well, let's just dot our T's and dot our I's and cross our T's. But the reality is if we approve plans, they're approved, even if we made a mistake. But the reason you're seeing it typically is because someone claims we made a mistake and staff is not agreeing. And we're saying, no, we, you know, and this is important to know, the burden of proof is not on the city. The burden of proof is on the person making the appeal to demonstrate that the city made a mistake, you know, by email or a signed off plan or something. And the next are substantive appeals. So these appeals, they're saying there's something wrong with the substance or the rules. They're saying that, you know, something happened where if we follow the rules, I'll be damaged. I won't be able to use my property in a reasonable way. So you get this in a couple ways. Typically you get it, or you may get it because something happened to somebody's property and it's not a legal conforming use anymore. So a good example would be, let's say they had a building that was built to the property lines, and then something happened to the building, it got destroyed or partially destroyed, and they want to rebuild it, but now there's setback requirements. And so they're coming to you to say, hey, you know, I want to rebuild this even though it doesn't apply to the rules. And the situation may be that, because we do have a clause for that with the rules, but there are some requirements you have to meet. For instance, you can't have made that damage yourself. You can't bulldoze it in the night and then say, oh, you know, look, whoops, the building fell down, I want to rebuild it. And, you know, they've got to demonstrate that this was an act of God, or that they qualify under the rules. And so that's typically when they'll come to Board of Adjustment, is when there's not an agreement between the city staff and them about what they're allowed to do in terms of rebuilding something that's no longer permitted. Now, the second big category of a substantive appeal is they're asking for a variance where they're saying, based on some set of criteria, I don't want to follow the rules. or I shouldn't have to follow the rules. Now, we need to talk about this because there are some things that should qualify and shouldn't qualify as justifications for a variance. Typically, there's something unique about your lot or your building where if you follow the rules, it would create a hardship, an undue hardship, and you wouldn't be able to reasonably use your land. Let's talk about that a little bit. What is a hardship? If somebody's claiming I have a hardship, what does that mean? Any board member want to pipe in here? What is a hardship?
A condition created where the person cannot reasonably use the land to what they need to do.
Wow, I guess we know why you're the chairman. That was like textbook right there. That was good. You're exactly right. A hardship, if you look in red, is not a personal hardship. And I think just calling it hardship maybe that's sometimes why we lean that way, because the word itself sounds like, oh, you're going through a hard time. Let's give this guy a break. Let's give this lady a break. She's going through a hard time. No, that's not what a hardship means. It's not because they're personally, financially having a difficult time. That shouldn't even come into the situation. You shouldn't even know. That shouldn't even be part of the explanation. What a hardship is there's something about the land or the building, there's something uniquely created there that they didn't create themselves, that if the rules apply to them, they're not going to be able to use their land in a reasonable way. So some good examples would be if you have a lot with steep slopes and they have to build in the setback, otherwise they don't have room to put it in the middle. Or irregular shaped lots where we have rules about irregular shaped lots in the subdivision ordinance, but sometimes they just can't anticipate the weird shapes that you get lots in. And if we follow the rules, it would give them like a little tiny bit of buildable area. And so we bring that to you to make exceptions. Those are good examples of variance. Now you will see it's not always that we're in a disagreement. Typically as staff, we really think through this, and we don't want citizens, we don't want residents to have undue hardship either. So we can recognize, oh, whoops, somebody wants to share their screen there. Let me put it back. We can recognize when there's undue hardship, and we might encourage someone actually to say, hey, look, we can't let you build this the way you want, but you can ask for a variance and we would support you because you have an irregular shaped lot or you have a situation. What we want to get away from and where we were before was there was maybe a misunderstanding with staff and with the city where the Board of Adjustment was just seen as oh, you don't like the rules? Well, go ahead, go to the Board of Adjustment. Maybe they can give you an exception. And as you recall, we were getting several, 2 or 3 a month. And because of the training we did last time with all of our staff, we made it very clear that this is not about personal circumstances. This is about having a true hardship. We were able to cut that down where we haven't had a meeting in over a year because it's not used as an outlet anymore for that. And the one big comment I want to make with that is that if you go back to this slide, changing the rules versus allowing exceptions. If we want to change the rules, if we don't like a rule and we say, hey, who cares about setbacks and this person, it costs too much to do it that way. Well, let's change the rules for everybody. And if that's the case, we need to take it to City Council because it's their decision, but also because that allows for a public input process. What the Board of Adjustment should be used for is to really look at just exceptions that have to do with unique circumstances of the lot or the building. So a big thing too, hardships can't be self-created. So somebody can't buy a normal size lot and then divide it into some weird shapes and then say, hey, can I get an exception? No, that wouldn't work. And also, oftentimes you'll get somebody that will build something first and then they get stopped. And then they come to you and say, oh man, I just spent all this money to build it. Can I get an exception to allow it? I mean, I already built it. If you make me tear it down, that's an undue hardship. Well, no, they created the hardship because they built it first without permission. So even though you want to say, oh man, I'm sorry you did that, but if the building was already there before, that's different. That's illegal non-conforming. But if they built it and now they're asking for forgiveness. That's, again, not an example. That's a hardship they created themselves because they didn't follow the rules. Now, related to that, I want to say, Rafa, do you remember what one of the big claims is of some people that say, and remember we went over and talked over in Nuevo Laredo? Do you want to share that example of that story, Rafa?
Can you repeat that, please?
Do you remember a lot of the example people say when with the rules is they say, oh, well, I didn't know because you know, over in Mexico you don't have to you know, they don't have any requirements. You can do whatever you want. Do you remember that?
Yes, absolutely. Yeah, some people have the mindset, the belief that some of these rules don't actually exist based on where they're coming from. So that's unfortunate.
But what happened when we started going over regularly and meeting with the planning staff over and the building staff over in Nuevo Laredo? What did they tell us?
Well, yeah, they tell us that sometimes they do have a process, and they actually do have quite a few people that are inspectors out in the field carrying out and finding deficiencies out in the field.
Yeah, it may not surprise you, or it may surprise you, but it's not the Wild West over in Mexico. They have building code requirements, they have planning and zoning requirements, and actually, when we got into the nitty-gritty, theirs were more strict in some areas than ours. And they have building inspectors who go out and cite people and do stop work orders. And, you know, they have some differences in setbacks, but basically they still have what we have over here. So that excuse that, oh, you know, I'm sorry, I'm used to that over there and there are no rules. That's just simply not the case. There are rules there, and just like there are here.
See, that honestly, Kirby, is the big issue. People come in with hat in hand and begging for forgiveness because they claim that they didn't know, but yet they can build an addition onto a house in a weekend where, you know, Edgar doesn't have a chance to, the enforcement people may see everything good on Thursday or Friday, and then on Monday, all of a sudden there's a building there. So that's where I was talking about earlier, that there's got to be some teeth, because other than that, we tell them, no, we're not going to give you the variance, but yet nothing can be done. Nothing's done.
Yes, that's a great point, and that's something we're going to address with the RICO to give it a little more teeth there. You know, we're not the Gestapo. We're not going to like go in and break down people's doors because they are violating a setback. You know, there is a due process that we follow, and there's fines, and we take it to the judge, and you know, there's a process, and we want it to be fair, and we want to be as understanding as we can. But at the end of the day, the rules are the rules. And if we want to change the rules, that's fine. But it's not this body that gets to do that. It's the city council, so that we can provide the public input that is necessary to change the rules for everybody. Okay, so continuing on about hardship. Hardships have to be unique to the property. So a good example would be, you know, the steep slopes, but also that they're something common to the area. You know, we might have rules that say, hey, we shouldn't build on properties with slopes. And as long as it's a citywide rule, that's fine. But if we don't have that rule and it's creating a hardship for one person, that's when we say, hey, the rules don't quite address this circumstances we didn't foresee. And again, the city's rules can't be the hardship. Somebody could come in and claim, oh yeah, if I have to build to the city standard, well then, you know, it's going to be too expensive for me. You know? No, the city's rules aren't a hardship. They're only a hardship in the case that it's so restricted because there's something very unique about that property that they don't have a reasonable use. So let's talk about reasonable use, because this is in our local ordinance. This is in the state code. Basically, like you said, Mr. Averill, a hardship is where the city's rules apply to a lot, a unique lot, in such a way that they don't have any reasonable use of the land anymore. So what is reasonable use? Anybody want to chime in? Any board member that hasn't spoken yet want to speak? What do you think reasonable use is? Does reasonable use mean they can do whatever they want on their property? What do you think? Javier?
No, it doesn't mean that. I kind of feel like it means that if you can conform to the codes that are in place, and you can provide sufficient plans to the building department that you're doing that, well, that's the reasonable use of the property. You can't just come and say, well, I'm gonna infringe on the setbacks and I'm just gonna do it because I want to do it. And I don't think that's what the rule's intent is.
Yeah, you're exactly right. You're exactly right. A reasonable use doesn't mean you get to do whatever you want, wherever you want it, because if that were the case, I think most people would want to use, well, not most, but a lot more people would want their property to be commercial and not residential because there's more money in it, and often we see that. We see people wanting to do something commercial because they can make more money off of it, but it's not zoned commercial. And cities do, and the state agrees with this, cities do get to decide where things go. And not everyone gets their land to be a commercial property. So reasonable doesn't mean they get to do whatever they want. Reasonable doesn't mean that it's more expensive. Yes, sometimes the rules make things more expensive. For instance, let's say you had setbacks on a property, but you wanted to build a 2,500 square foot building, a home, but if you use the setbacks and you were only going to do one level, you could only get 1,000 square feet in. Well, it's cheaper to build one level, so they would like to violate the setbacks to just build one big 2,500 square foot property or building because it's cheaper just to do it on one level. But they're allowed to go up 2-3 levels. They just don't want to because that's more expensive. But that's what the rules were put in place. Oftentimes, one of the reasons we have setbacks is because people want some separation between their neighbors. And not that I agree or disagree. That's just the way the rules. That's justification for the rules. So in other words, that property owner could go 2 stories up and get 2,500 square feet. And so they have a reasonable use. They can comply. It just means that it have to be a little more expensive, and that's fine. What we're really talking about with reasonable use is that if the potential, if they're not able to use their property in any reasonable way, then we're starting to recognize that there's no reasonable use. And so if they can't use their property for anything, obviously they don't have reasonable use. If it's so restrictive they can do very, very little, that's where your determination comes in and says, yeah, it's getting unreasonable, city staff. I mean, if they follow the rules, they can only do these very limited things. So I think this complies. In other words, what I'm trying to say is there's a gray area. On one hand, it's not they get to do whatever they want. And on the other hand, it's definitely not that the city should be so restrictive they can't do anything. But then there's an area in the middle where, well, there's very limited, maybe too limited. And that's where you can step in as the Board of Adjustment and say, okay, we're going to grant a variance in this case because it's the rules in this specific condition of this lot make it too limited, and we want to give them a little more room. All right, Rafa, do you want to take over with the conduct of board meetings? Now, does anybody have any questions about anything we discussed up to this point?
Yeah, a quick question about hardships. What about physical hardships or like health related, to where we've seen people come to us that request a variance because of they're in a wheelchair, and somehow that requires them to ask for a variance?
Yeah, that is a great example. And as staff, we have an outlet for that in our land development code where we can make exceptions. And the important thing is that just because they don't get to make the exception necessarily the way they want, for instance, violating setbacks because they want to put in a ramp, that's a process we can allow for through the city's code to make a property ADA. But maybe they don't want to put it where the city says, yeah, that makes sense. Maybe they want to put it somewhere else. Maybe they want to, and so in other words, there still is a process for those. And I think the example you're probably thinking of that was tricky was that property where they said, well, we want to extend our home, but we don't want to do it on a second story. We want to do it on the first story because the first story is accessible to the person we're going to have in a wheelchair, right?
Yeah.
Was the condition, and that is a tricky one. But if you looked at that case, you remember the details of that case, they could have built, they had other area they could have built. In other words, they weren't maxed out on their buildable area. They just chose a certain area that violated the setback, and that was where they built. And essentially it was because they didn't consult with us first. They just started building without a permit. So they were using that as an excuse after the fact. They didn't come to us first. If they came to us first, we'd say, well, you still got all this area on the other side of the home. Why don't you use that side? You can still reasonably accommodate that person. You don't have to violate the setback to build that second area. I'll just tell you anecdotally, if we get somebody in that's the reason they need to violate some of the rules, we have the ability to work with them and we want to work with them. But, they may use that as an excuse after the fact, and that's where it can get a little tricky. And that is certainly something you can look at. But again, as staff, we'll be providing guidance on those to say, well, they can still, within the rules, accommodate the need that they have. And then you can make your decision.
Kirby, I had a question also. I know that Mr. Averill and some of the other members also discussed with you a couple of times about kind of like a screening process for people who are requesting variances sometimes. I don't know if the charter was changed or anything like that, if those things have been considered as well to kind of streamline what comes to the board through I know me and Pancho have talked about it. It's been some time, so I can't remember all the details, but if we had some kind of screening process so that, I know it's costly for people to come to the board, and if it's already going to be something that's not going to be able to cut the mustard, I mean, sometimes they have to be told that, there's no hardship here. You're not being denied, reasonable use of your property. And I understand your desire, whether it's personal or whatever, financial or whatever, but it doesn't necessarily constitute any kind of hardship or something. That kind of, I don't know if you can not let that application come to the meeting or not. I know we talked about it some while back, and that's why I wanted to bring it up.
Yeah, we looked at having an administrative process in place to help with the number of cases that were coming through. But then what we found was after we did the training for the staff and the board and other city staff, we found that the requests for Board of Adjustment just really dropped off. And so at this point, before it was a problem because we were getting multiple requests a month. Now we realize that with all the training, we're explaining it correctly and we're not getting those in. So I don't think we necessarily need an administrative because we're not meeting as regularly anymore. If that changes again and it gets to where we're having a lot, then we probably need an administrative process to streamline the ones that are obviously would be granted a variance or obviously not granted a variance. But at this point, I think, unless we receive direction otherwise from the board, that we probably don't need an administrative process right now because we've really brought that workload down by just training everybody and explaining it correctly. Does anybody else have any questions up to this point? We've got about 5-10 minutes left. Rafa?
Yes. So one of the things that's very important about the meetings is the way the meetings are actually conducted. The meetings are a public meeting. They are recorded, minutes are taken, but it's also very important that they be conducted properly for the benefit of the public. Now, in the order of the meeting, when we first start out, staff is given the opportunity to make their presentation and they present their case completely. And then yes, sir.
If I can interject just for a minute, before that wasn't always the case. You remember, it was only the last 1 or 2 meetings where we started to change the process to be like our other boards, and we asked your permission to do so, but that's the way we'll be doing it when we have these meetings in the future. Instead of having the applicant come up and explain their case and you're curious, like, well, we want you to get all the facts laid out very simply in a very clean presentation, and then allow the applicant to speak, to disagree with staff, to say, well, I don't see that perspective, or yeah, I agree with these facts. So if you recall those last couple meetings, did you like it the way we did it? And is that the way you want it to continue? So what we're suggesting here is we make a presentation first, and then we turn it over to the board to question the applicant and anyone else.
I think that's a wise way to do it, because that way we hear it from the city staff first, and then we go to the individual.
Okay, thank you.
Yes, Mr. Chairman. And staff is there to be a good resource for the board. Now, after the staff makes their presentation, then the applicant is allowed to make their case. And one of the things that we need to keep in mind is not to be argumentative, and just to understand that what we really need to get at the heart of it is the evidence. It shouldn't be an issue of an opinion. but more of getting to the evidence, and the burden of proof is on the applicant. Now, once the hearing is closed, the applicant should no longer speak, and it's very important that the board does stick to that. And when the board does make their motion and decision, they should cite the findings and the reasons for the decision. Again, since these are recorded and minutes are taken, it's very important that the reasoning for the decision be clear, because it does create a record for review in the future.
Yes, Rafa, and I'll interject again to say that, 99 times out of 100, it doesn't go any further than the Board of Adjustment. But in that one case that it goes to the district court judge, it is going to be very helpful for the judge to then be able to watch the meeting and to see how things were done orderly and to see why you made your decision. The reason you decided to vote actually does matter. It matters that hey, this is if you make a motion, I'm motioning and it's because of these reasons. That's going to very, very much help the judge in the case it goes to.
When the meetings are conducted, you do follow the Robert's Rules of Order, and the motion is the proposal that the entire membership takes action. Now, the motion that is made is what's very important and drives the beginning of the decision. So motions are moved, then seconded, they are discussed, and then at the end they are voted on. Now, when voting on a motion, the motions are done in order. It is very important that the members obtain the floor properly and not to speak out of order. The other is to speak clearly and concisely as the notes are being taken, as a meeting is being recorded. Now, one of the challenges, and that we saw a little bit in the beginning when this meeting was being started, was that we were having a couple of technical issues with the WebEx meeting. So that's why it's very important that we speak clearly, concisely, and that those issues are taken care of for the record, for the public later on. One of the things that we need to also follow is the rules of debate. And most importantly, which is highlighted at the bottom of the slide, is to be very courteous. We must be courteous and respectful of all those participants as well as the other board members.
Yes, and Rafa, I'll add to that as city staff, that is our aim, but also in the positions you sit in, you also represent the city. And so it's very important. I know sometimes our personality may not fit with the conduct of a meeting. I mean, if you may be someone who wants to speak more freely and throw your opinion in and maybe joke a little, but when you're representing as a board member, for the public especially, they don't know that you're just a volunteer and somebody they are seeing a city official. And so it's very important for the public, I think, to maintain that level of courteousness and respect to everybody, including your fellow board members.
I have a question on that. Rafa, you're speaking about the people that are coming up to discuss it on, let's say, on the applicant's side. Is there a limit of time that we can give to these people? Because we have had issues where, and I think that we had one, I think it's probably the last meeting of last year, where we had 2 council members come up and, past council members had come up and they're discussing it. And it's obvious that they're trying to put their 2 cents in. I don't know if they're trying to intimidate the board or whatever, but it would be great if we had a timed amount or a number of speakers on that behalf.
Chairman, can I say something about that? It's Louis LeVode. Mr. Chair, can I say something about that?
Go ahead.
I don't think we have a time crunch like city council would have a time crunch where we have to limit people's time. I always feel like limiting people's time is sort of like cutting off their speech. I don't like to do that unless we have some kind of time crunch. I've never seen a meeting that we have too many items. Number 1. Number 2, how many people can go to bat for somebody? I think that's something the committee can decide, how many people can go to bat for somebody. 3, 2, I mean, I think that's reasonable. I mean, you don't want, 14 people getting up one after the other in support of something. It's like, I think after, 2, 3, okay, we got it, but I don't think cutting people off time-wise is good.
All right. Thank you.
So from a staff perspective, it's certainly within the discretion of the chairman and the board to determine how long people speak. And so, one of the board members could say, Chairman, can I motion that we limit the discussion? Do we limit speakers in this amount? Or if there's somebody speaking, you might, interject and say, Chairman, would it be possible we could, maybe continue for 1 more minute and limit it after that?
Maybe if you see something going long, you would do that. But otherwise, that in and of itself is just kind of, we're not city council. Okay. City council likes to do that kind of stuff. It's not proper here. We're not on a time crunch.
And certainly that's the point that I was getting at, that it's your discretion, it's your choice. And so there is no rule that says you have to, or you have to hear this many speakers, or it has to be this long. It's your preference, and it's up to you, and it's the board's decision. The one thing I will say that you should try to stick to is that when someone is presenting, that they should be presenting evidence. And so if somebody's speaking to the character of the individual, if they're speaking to the financial situation of the individual, those are things that should not be weighing in. And so you could remind them. It would be appropriate to interject and say, thank you, speaker, I really appreciate you coming to be here for the applicant, but do you have anything that relates to the property, to the uniqueness of the property, not the personal circumstances of the individual, but the unique circumstances of the property? And if they say no, you can say, well, thank you very much for what we're trying to ascertain, facts as they relate to the property. That's certainly something reasonable you could remind them. Okay, Rafa?
Now, in continuation with regards to the board meetings, there are 5 members and 4 alternates, and the alternates are decided by a lottery. And what's very important is to remember that there are 4 of 5 votes are required for any motion, and the terms are for 2 years.
Now, this is something we have not been following in the past, and it's been this case for a long time. Going forward, this is something we're going to stick to because this is the rules. Now, if we don't like the rules and we want to change rules, then we can do that. And I'd like to hear your input as board members right now, because we have a chance to change the rules with Recode. And we'll have to double check it off whether this is not in the charter. I don't think it is. And this is just city ordinance. But right now, the way the rules are written, there's only 5 voting members at a Board of Adjustment meeting, and you need 4 out of 5 votes to make a decision. But the way I think in practice it's been occurring for a long time is all 9 members are coming to meetings, and all 9 members are voting. I mean, all 9 may not show up, but any of the 9 can, and any of the 9 can vote. That's our understanding. Is that correct, board members? That's how it's been done for a long time?
Yes, that's correct.
Yes, and now, like I said, unfortunately, that's not the way the rules are written. So going forward, we're going to stick to the rules. But do you want to change the rules? Would you prefer it to be 9? No, the only thing I'll say is the reason 4 out of 5 votes is required for any motion is because it was intended that there be a high threshold. In other words, 5 board members can vote, and 4 out of the 5 need to agree. It was never intended to be a simple majority. So I think we need to stick to that. Even if we were to change it to 9 members, we need to keep it maybe 7 out of 9, or we need to keep that threshold high because that's the intent that's in there. But do you have any opinions about this?
Kirby, I'm probably right now the longest serving board member right now. So if there's a 2-year term, there's other board members that have been there longer than 2 years also. So, and I have no problem if they.
Whoops.
I don't know if that's a charter issue or.
I'm not aware of the term. I think you serve at the pleasure of your city councilman.
Well, you do. That's correct. However, it's 2-year terms that then should be
until that city councilman discharges you, you still serve.
Yes, and that's something we can look at to maybe make a little, because in practice, that's probably what they're thinking as well. If they didn't pick somebody else, you're still the guy. But by the rules, if we're following the rules, it's a 2-year appointment, then you need to be reappointed if you continue.
Where is that rule?
That's in the local, that's in our city code.
Also, Kirby,
Yes, sir.
I don't know if it's the same, but in planning and zoning, you can only serve 8 years. Doesn't matter if you're appointed by 4 or 5 different people. You can only serve 8 years.
Yeah, that's not a requirement. That's not a requirement
Okay.
for the Board of Adjustment.
Okay.
And Kirby, like, I'm not opposed to having more individuals participate. I can understand sometimes why term limits are put in place to try to get, more citizens involved in even the Board of Adjustments. The problem also has been that we weren't getting quorum. There were years in the past where we were not able to even get quorum. So I just throwing that as food for thought out there.
We appreciate all of that. And so we want to balance following the rules with the reality of the situation. But we are going to be, nobody is kicked off because it's over 2 years. I'm not saying that. If you're there, you're going to continue to serve if and when a replacement happens, or if you're reappointed. No one's getting kicked off. That's not what I'm saying. What I am saying is that definitely for the rule of 5, we're going to be following that going forward. Now, the problem is right now we only have 2 that are identified as alternates. That's Javier Martinez and Luis Laval. I'm sorry if I said your name wrong, Luis, but is it Lavad? Is that right?
How it's Labode. But how are these people, how are they elected as an alternate, or how are they appointed as an alternate? What is the process there?
Yes, very good. So what the rule says is that you're appointed as a Board of Adjustment member, but then the members and the alternates are selected by lottery. And it doesn't say how often that lottery has to occur, so I would leave that up to the board. But at some point before our next meeting, whoever shows up, we'd have to pull a lottery to say who are the members. You could do that every meeting. I think that's unnecessary. What would be good is probably at a meeting where you designate at least for a year, you say, hey, let's draw straws in a way. You could do it several different ways, but you say, let's designate who they are the members and who are the alternates. Now, what does it mean to be an alternate? You still show up to the meeting, and if we don't make quorum, you join in and you vote. You can certainly participate in the meeting, but you're only voting if you're a member.
I think,
that sounds a little complicated. Why not just increase the number to what do we have? 9, like you said, or what is it? And that's it.
Yeah, that's an option as well. I mean, we can't just decide the rules are different, but we can change them as part of the fee code.
These alternates rotate in some lottery basis?
That would be up to the board to determine.
Not only that, the alternate represents a certain district, and if the item that you're talking about is in that district, don't you think that the alternate should be allowed to, should be allowed to vote, because he's representing the district that the problem is in?
Wait. Can I just ask Kirby, this is not the way we have it right now, is it?
This is the way we have it right now, but we're not following the rules.
About these alternates that we're supposed to rotate on a lottery basis?
No, there's nothing about rotating. It does say that it's determined by lottery. So as a board, you could determine if that's,
Why do you determine Javier Martinez and I as alternates?
That's what we have on our records, but I'm not sure how or why you would determine. That's just you've been noted as an alternate.
Well, I think that makes good sense. I think we need to increase the number and talk about what kind of quorum we require for that number.
I say you go to 9, just like we have now, and 7 or 70% that show up represent pass the motion.
I agree with you, Ricky.
If everybody likes that idea, that's something we can add to.
I agree with you. That makes it a lot simpler, cleaner. And we have the rules about people that don't show up more than 2-3 meetings or something like that.
That's right.
Yes, we do.
Okay, so well, this rotating lottery alternate, that's crazy. That's a nutty idea.
Thank you, Mr. Laveau. Can we hear from some of the other board members? Everybody feel good about just making it's simpler with 9 and a 7 out of 9, or a majority, a 3/4 majority of the
Yes,
I would say 5.
I agree.
No, I think it has to be the higher number,
7
like 7.
or 6.
3/4 majority, because you may not always have 9. You may only have 6 that show up to a meeting, which means you need 3/4 of 6. You need,
which would be 5. Would be
Exactly.
You'd round up.
So I'm saying 3/4. Don't pick a particular number, because you may not have 9 members show up.
You're right.
Okay, well, we'll take that direction into how we're redrafting the code. Now, if a meeting occurs before then, before the new code is adopted, we will have to stick to the rules that we do have right now, which are, it's 5 voting board members and 4 out of 5 make the decision. 4 out of 5 have to agree.
When do we get to change this? At the next, aren't we having a meeting right now?
No, we're not taking any, there's no case before us. This is just a training. But, you know, if somebody brings a case to the Board of Adjustment, we will need to follow the rules that are.
But wait a second, when do we get to change this rule that we were talking about?
That's going to go to council in the spring with the.
So you just made up this lottery rule then about, lottery.
No, I didn't make it up. It's in the rules. We just haven't been following it.
The lottery's in the rules?
Yes, sir.
Okay.
Yeah, and just for clarity's sake, maybe I'll pull it up. You know what, we'll take a little, let me come back to that, because others may want to leave. I'll do it at the end of the meeting. If anybody wants to watch, I can actually bring it up. But just for the sake of everybody else, let me just continue, because there's only a few slides left. So, thank you very much, Rafa. Just continuing with, I want to highlight a few things with ethics. We have a code of ethics that we're required to follow. All board members are required to follow. As the Board of Adjustment, you're specifically called out as city officials, so you have the highest standard of ethics that's required by the city. Now, I'm not going to go through all the rules because it's several pages. I just want to highlight a couple things. One is the general rule that you need to avoid the appearance and risk of impropriety. Basically, nobody, you or in your family or in your household, should be economically benefiting from any situation. Now, the threshold, if it ever comes up when you think, oh, maybe I need to recuse myself, this is the standard the city lays out. That you can't be, first of all, that this person can't be a member of your household. So it's whether they're related with you or not, if they're living with you, that's your household. Then there's another additional standard. They can't be related to you by 3 degrees of consanguinity or affinity. What does that mean? Consanguinity means you're related by blood. Affinity means you're related by marriage. So here are some examples. The 3rd degree would be a great-grandparent or a great-grandparent-in-law or a great-grandchild-in-law or a great-grandchild. So you get it. It's pretty easy. But that's when you need to recuse yourself. And there are a few other ways, but I would recommend reading through those if you haven't in a while. They're very important. You and the Board of Adjustment are specifically called out as being officials that have the highest standard of this. One last thing I want to point out, this is in our Code of Ethics. This is not me speaking. This is our Code of Ethics the city's adopted. You are appointed by a council member, but you are not a representative on this board. And sometimes I know we can confuse the two. And in fact, Mr. Rivota, you were, well, no, it wasn't you. I'm sorry, I didn't know who was speaking, but somebody said, well, what if something happens in a district? Shouldn't that alternate be speaking because that's the district they represent? Actually, no.
That's me.
By the ethics, you do not represent anybody. When you come as a Board of Adjustment member, you're not representing your district. You're not representing your council member. You're not representing any political party. You are representing no one. You're coming in as a judge to provide your best judgment of what you think is right and wrong and how the rules should be interpreted. So it would be inappropriate for somebody to call you to say, hey, you represent me, you should be voting this way. That would be against the ethics of the city. So I want to make that clear. I'm not suggesting it ever happens. I just want to make it clear that we do have these rules. They are important, and we have the city's trust in these decisions we make. And it's very important that we take that seriously. With that said, that's it for the presentation. Does anybody have any questions? And then everybody else can, if we don't have any questions, we can excuse everybody. And those that want to stay on, we'll look at the rules specifically if you have any questions about that, the Board of Adjustment that's in the code. Anybody have any questions for staff or about this training?
I think it went very well. Kirby, I think where we're headed is in a great direction. Thanks to you.
Well, it's not just me. It is all of the staff here, the building and planning. I got to give a lot of good credit to Arturo Garcia, the new building director, not new anymore, but him and I are both relatively new. We've both been working in tandem to make things simpler, easier, to follow the rules where we have them. And if we don't like the rules, well, then we change them. But we should at least be following the rules that we have. And I've leaned on Arturo a lot, and we're both helping each other. And also, we have great staff. Rafa Vidauri and Jerry Pinzon, our building official. We have a lot of great staff, and so Arturo and I have made it an effort to really enable them to do a great job. It's a team effort. I can't take any credit beyond the team.
Kirby, thank you and your staff. I'm going to go ahead and opt out for now. Thank you.
Okay.
Thank you,
We have
Kirby.
one
Thank
final
you
item,
and your staff.
as this is a meeting.
Yeah, if there's
I
any,
motion that we end the meeting.
I
Second.
second.
I have a motion, a second to conclude the meeting. All those in favor?
Aye.
Aye.
Any opposed? Motion carries.